Darrell Brooks Jr., 21 CF 4596, 21 CF 5020. Appearances, please.
Matthew Torbenson and Shelley Grosso appear for the state. Good morning, Your Honor.
Attorney Russell Jones on behalf of Mr. Brooks. Mr. Brooks is present in court, Your Honor. Injury clothing. Good morning.
Good morning, everybody. Hi, Mr. Brooks.
Hello, Your Honor.
He's taking a plea.
We are here. It is the day that our trial was scheduled, but I have plea paperwork, and I understand that the parties have reached an agreement. Mr. Torbenson, do you want to put the state's offer on the record?
Case ending 4596. The state anticipates Mr. Brooks entering a no contest plea to count 3, second-degree recklessly endangering safety as an act of domestic abuse. Based upon that plea to count 3, the remaining charges would be dismissed and read in for consideration at sentencing. As to case ending 5020, the state anticipates Mr. Brooks entering a plea of no contest to count 1, felony intimidation of a victim. Based upon that plea, the state would move the court to dismiss and read in the remaining 2 charges for consideration of sentencing.
No trial.
At the time of sentencing, the state will recommend that the court sentence Mr. Brooks to a substantial term in the Wisconsin State Prison System. We would leave the ultimate interpretation of that to the sound discretion of the court. The defense would be completely free to argue for the appropriate sentence.
It also contemplates the amended information's not being filed.
Okay.
Last I heard it was because he refused to go into
you
court.
talked about
I don't know what's up.
Count 3 as charged, correct?
Yes.
Okay. All right. Mr. Jones, is that your understanding of the state's offer?
Yes, Your Honor, and I actually did an attachment of an email string between the state and I for clarity of the record.
Okay, I appreciate that. And
I had Mr. Brooks' initial next to the offer section.
great. You're planning or anticipating that it will be a no contest plea. Do you want to make a record as to why that is rather than a guilty plea?
Yes, Your Honor. My client is entering a no contest plea. In those discussions, I indicated that he understands that he'll be found guilty, but he is standing silent as to, he's not contesting the allegations because of potential civil liability, which he may or may not be exposed to with respect to these charges, and therefore we've negotiated a no contest plea. But I will tell you that he understands he'll be found guilty. This is not a maintaining of innocence thing. This has an issue. This is a legal decision based upon potential civil liability.
All right. And the state that was part of your offer, and you are willing to accept a no contest plea for those purposes?
I am understanding that the victim, Ms. Patterson, can still seek restitution in these matters if she so wishes. We are not objecting.
All right. All right. And the court is willing to accept it for the reasons that have been stated on the record. The named victim will have the opportunity to put in a request for restitution that is separate from a civil liability thing. It's so that will still be a potential that will be part of this. So, Mr. Brooks, it is my understanding that you are planning to enter a guilty plea today.
No contest.
Trial. I think it'll be
See, I told you I would do it.
I know you did.
It is habit. I apologize. A no contest plea to 2 of these charges that are pending against you. Is that correct?
Yes, Your Honor.
All right. Have you had any drugs or alcohol in the past 24 hours?
No, Your Honor.
Are you on any medications?
No, Your Honor.
Are there any medications you're supposed to be taking that you have not taken?
No, Your Honor.
All right. So you've been charged with a number of counts in each of these cases. It's my understanding that you're going to enter a guilty plea to the 2. Or sorry, did it again. No contest plea to the 2, and then the other charges will be dismissed and read in. What that means is, for the dismissed and read in counts, you will not face any penalty for those. Nor will you have a conviction for them. However,
so he's pleading no contest to 1 count of first-degree reckless endangerment in connection with a domestic violence assault, and 1 count of witness intimidation. And everything else is being dismissed against him. So like the 40,000 other charges are being dismissed.
when we get to sentencing, the state will make their argument as to the facts of the case, and they can argue the facts that relate to those dismissed and read-in charges. And I can take those into consideration when I sentence you on the 2 that you entered the no contest plea to and that you were ultimately found guilty of. Do you understand that?
Yes, Your Honor.
All right. So for the 2 that you are going to enter the no contest plea on, the first is a second-degree recklessly endangering safety with a domestic abuse assessment. That means that it is a Class G felony, and for that you face the
Oh, he
potential
pled to
penalty of
second
a
degree.
fine of up to
They upped the charges
$25,000
first the other
and
day.
imprisonment of not more than 10 years or both. That 10 years is broken down into two parts, 5 years initial confinement and 5 years extended supervision as a maximum. Do you understand that's what you're facing?
Yes, Your Honor.
In addition to that, because of the nature of the crime, that this is someone that you have been involved in a domestic relationship with, or either resided with, or have a child with, you would face the domestic abuse assessment for that, which is just an additional $100 penalty that would apply against you, as well as a federal ban on ever possessing a firearm. Do you understand that?
Yes, Your Honor.
All right. And then on the count 1 felony intimidation of a victim, that you're going to enter the no contest plea on in case 21 CF 5020. That is also a Class G felony, potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years, or both, broken into that 5 years initial confinement and 5 years extended supervision piece. Do you understand that?
Yes, Your Honor.
Do you also understand that if you were to be sentenced to prison, you would have to serve in prison each day imposed as initial confinement, because initial confinement time is not reduced by good time or by parole?
Yes, Your Honor.
Do you further understand that when we get to sentencing, I was not part of any negotiations, so I'm not bound by anybody's offer or recommendation? I will listen to what the state has to say, anything that the alleged victim has to say, either in writing or in person or in, I guess, any other form. Anything that your attorney says, anything that you say, and anyone who speaks on your behalf. I will take all of those things into consideration,
A
and then I'll
facility, they
sentence you as
call
I
it, which
see
I
fit,
believe
which
is a
could be
prison
up to and including the maximum
facility.
penalty. Do you understand that?
Yes, Your Honor.
Do you also understand that because these charges are felonies, once you are convicted, there's some additional consequences, including the fact that you will never be allowed to possess a firearm at any time in the future. You may not vote in any election until your civil rights are restored. You will have to provide a DNA specimen to the Wisconsin State Crime Lab for DNA testing. And because these are violent felonies as defined under Wisconsin law, you may never possess body armor at any time in the future. Do you understand that?
Yes, Your Honor.
Do you also understand that if you are not a citizen of the United States of America, the plea of guilty or no contest for this offense with which you were charged may
trial,
result in
Salvador.
deportation, the exclusion from admission of this country, or the denial of naturalization under federal law? Do you understand that?
Yes, Your Honor.
Do you further understand that if you enter a no contest plea, you will be giving up all the same rights as if you had pled guilty? And at the end of this, even if you enter a no contest plea, I will find you guilty of these crimes. Do you understand that?
Yes, Your Honor.
All right. So what is your plea then in 21 CF 4596 of second degree recklessly endangering safety with the domestic abuse assessment?
No contest, Your Honor.
All right. And in 21 CF 5020, intimidation, felony intimidation of a victim.
No contest, Your Honor.
All right. Now I have in front of me your plea questionnaire and waiver of rights form. Did you go over that with Mr. Jones and sign off on it today?
Yes, I did, Your Honor.
Do you understand that when you say no
he's
contest,
taking
rather
the
than
plea to
asking
2
for a
counts.
trial,
The
you
rest
give
are
up a
being
number of
dismissed.
constitutional rights that are guaranteed to you? Those include your right to remain silent and not incriminate yourself, the right to see and cross-examine the state's witnesses, as well as call witnesses on your own behalf and have them come to court to testify for you, the right to actually have a trial, which could be a jury trial where 12 people sit together, listen to the evidence, and then must agree as to each element prior to reaching a decision, or a court trial where the judge listens to the evidence and makes a decision. And finally, the right to make the state prove you guilty by evidence beyond a reasonable doubt that you committed the crimes charged. Do you understand you give up all those rights when you say no contest rather than asking for a trial?
Yes, Your Honor.
Do you also realize you're giving up the right to raise any motions, such as suppression of the evidence, identification of you as the person who committed the crime, suppression of any statement you may have made, or any challenges to the information or the complaint?
Yes, Your Honor.
Do you also realize you're giving up the right to raise certain defenses you might have, such as insanity, self-defense, intoxication, alibi, coercion, and necessity?
Yes, Your Honor.
Did anyone make any threats or promises to get you to enter into these pleas today?
No, Your Honor.
Did you read and understand the criminal complaints that were filed in these cases?
Yes, Your Honor.
And did you discuss with your attorney the elements of these offenses?
Yes, I did, Your Honor.
Do you understand that if we had a trial, the state would have to prove as to the second degree recklessly endangering safety that on November 2nd, 2021, at 7311 West Capitol Drive, that you endangered the safety of another human being, that you endangered the safety of another by criminally reckless conduct. That criminally reckless conduct means that the conduct created the risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and you were aware that your conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means serious bodily injury, injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily injury is great bodily harm. Do you understand that's what they would have to prove at trial if we had a trial in this matter?
Yes, Your Honor.
And you understand that by pleading no contest, you are admitting that you believe that the state has adequate evidence upon which they could convict you, and you are opting not to challenge that evidence. Is that correct?
Yes, Your Honor.
All right. As to count 1 in 21 CF 5020, do you understand that's the felony intimidation of a victim, that if we had a trial on that matter, the state would have to prove that between November 5th, 2021 and November 15th of 2021, from 949 North 9th Street, that, what are the initials? EP?
Yes.
EAP, was the victim of a crime, that you prevented, dissuaded, attempted to prevent, or attempted to dissuade EAP from reporting the crime to any law enforcement agency, and that you acted knowingly and maliciously. Do you understand that's what they'd have to prove as to the felony intimidation of a victim?
Yes, Your Honor.
And you understand that by entering that no contest plea, you are admitting that the state has adequate evidence that they could use to convict you of that, and you are opting not to challenge it. Is that correct?
Yes, Your Honor.
Have you had enough time to go over this case with your attorney?
Yes, I have, Your Honor.
Are you satisfied with his representation?
Absolutely, Your Honor.
Do you have any questions, or are you confused about anything we're doing here today?
No, Your Honor.
Are you pleading no contest because, again, you understand the state has adequate evidence upon which they could use to convict you, and you are opting not to challenge that evidence?
Yes, Your Honor.
And are you entering this plea freely and voluntarily?
Yes, Your Honor.
Mr. Jones, have you gone over the plea questionnaire and waiver of rights forms with your client?
I did.
Are you satisfied that your client understands the nature of the charges, the elements, the maximum penalties, and all of the rights that he's giving up by pleading no contest, including the fact that he will be found guilty, and also including any possible motions or defenses?
Yes, Your Honor. And to that end, I also handed Mr. Brooks about 100 and some pages of reports today, just so he would have them, the witness list, the amended information, and there's additional documents I'll be sending to him. Although he has them on digital format, I wanted him to have them in paper format. We went through the no contest discussions. We also had a discussion, not just today in your bullpen, but also, and I'm not getting into the substance of it, but also on Saturday, we were able to have a fruitful conversation. So I think that Mr. Brooks is doing this knowingly and voluntarily.
All right. Are you satisfied that alcohol, medication, or drugs are not affecting your client's ability to understand what he's doing in court today?
I am.
Are you satisfied the plea is being made freely, voluntarily, and intelligently?
I am.
Are you aware of any reason in law why I should not accept this plea?
No.
Does the state consent to the jury waiver?
We do.
All right. The court approves the waiver and finds that the defendant is entering this plea freely, voluntarily, intelligently, and with full understanding of the nature of the charge, the maximum possible penalties, and all of the rights being given up by pleading no contest, and the court accepts that plea. Mr. Jones, may the court use the facts in the criminal complaints to stand as the factual basis?
Yes.
All right. Mr. Brooks, you said that you read and understood the criminal complaints. Are you agreeing that you believe that the state could prove that those facts are true, and therefore you are opting not to challenge them with your no contest plea?
Yes, Your Honor.
The court finds that there is a factual basis for the acceptance of your plea, and based on your pleas of no contest, the court now finds you guilty of the offense of second-degree recklessly endangering safety with the domestic abuse assessment and felony intimidation of a victim in the manner and form as charged in the information, and I judge you convicted as of today's date, and I order judgment of conviction to be entered into the record. Is the state moving to dismiss and read in the 21 CF 4596 counts 1, 2, 4, and 5?
Yes, and counts 2 and 3 on 5020.
Okay, you got there before I did. That's fine. All right, those will be dismissed and read in for the purposes of sentencing. It is my understanding that we're setting sentencing off for another date. We will select that date in just a moment. At the time of sentencing, Mr. Brooks, and I am going to keep this. This was, I had this case in the domestic violence court. I came to another assignment, but I kept it because I had done much work on it, and I thought for continuity it was best. I will be transferring to another assignment in August. If we get a date before that date, I am specifically keeping this case. I will see it through. So at the time of sentencing, I am willing to listen to oral statements of counsel as well as anything that you have to say, Mr. Brooks, as well as EAP. If you would like to have a friend or a relative speak on your behalf, I'm more than happy to talk to that person. If there's more than one person who wants to do that, they should put their comments in writing and get them to Mr. Jones so he can electronically file them at least 3 days prior to that sentencing. If there are issues of restitution, that will be determined at sentencing if possible. Is there a request for a pre-sentence investigation?
No.
No.
All right. And
Oh,
I'm not moving
then
for
right now
remand. I
then.
normally would in a case like this, but given where Mr. Brooks is serving a sentence and my understanding that Mr. Brooks wants to return back to Boscobel, I'm not asking for remand.
right, I agree with that.
He wants
Generally,
to go back to the prison. He
I
didn't
would
want us to
remand
get
someone
jailed
given the
for trial.
seriousness of the charges that you just entered into and that what the state's recommendation of substantial prison would be. But given your situation, I don't want you to have to be held in the Milwaukee County Jail rather than returning to the prison setting where you have been housed. So I am not going to remand for that specific reason. I know you will be held. That is the court's goal, that you be held in custody, just not necessarily here. So
Thank you, Your Honor.
you're welcome. All right, so I have some warnings for you. You may not have any firearms as you are now a convicted felon. The maximum possible penalty you face for violation of that is a $25,000 fine and a 10-year period of imprisonment. You cannot vote until your civil rights are restored. You may not possess body armor, and any no contact order remains in
go back
place
to
at
his
least until
boyfriend's.
after sentencing. All right, we will select a sentencing date, and I will see you then.
Thank you, Your Honor.
You're welcome.
What day is sentencing?
Parties available August 9th at 9 o'clock.
No. That week I can do any of Monday, Tuesday, or the Wednesday, not the Thursday or Friday.
That week is not good for this court.
Okay. Then the following week is a good week for me, except for Monday.
Okay.
Generally.
August 16th, 9 o'clock.
That'll work.
Works for the state.
Yes.
Next court date will be August 16th at 9 o'clock for sentencing.
Friday, August 16th.
All right, August 16th. Yeah, I know, it's funny. He didn't shoot anyone, but he's not allowed to have firearms anymore. Well, that's kind of disappointing. This is like the 4th trial in a row for Salvador that hasn't gone. 3 of the last 4 were mine. I know this is probably best for the court system and all that. I don't know why he's in a wheelchair. Everyone's been asking that. The rumor was that he refused to enter into court, and so they strapped him to a wheelchair and wheeled him in. But he's been really cordial. So I don't think it's that. It's weird. I don't know what's going on with the whole wheelchair thing. Yeah, I know, right? Like everything that involves Salvador, we don't get to the good parts. Yeah, I know. Oh, this was going to be a good one, I think. But okay. Well, that's all we have. So Brooks pled no contest to 1 count of second-degree reckless endangerment. They had increased it to first-degree reckless endangerment, but apparently they offered him a plea of second degree, and then they added like 6 counts of witness intimidation at the last hearing last week, and he pled no contest to 1 of those counts today. So both 10 years, and that's about all we have. Yep, the feed went down. Hang on a second. Let me cancel the speed. Okay, so now I don't have noise in my ear. That was it. Good meds, you think? Have them under control? Wait, hang on. Yeah, I don't know. Maybe he wanted to get away from his housing for this trial. But the judge's comment was that he wanted to get back to it. So, or not the judge's comment, I think the prosecutor's comment. So maybe generally county jails are a lot worse as far as amenities and everything than a prison system. So maybe he's like, hey, I'm going to be found guilty anyways. I'm doing 6 life sentences anyways. I don't want to hang out for a month in this stupid county jail. I'm just going to go back to prison where my boys be. You think he's right about meds? Lou, by the way, you and I need to do a stream. We need to talk about some stuff. But glad you're here. Let's see. As long as he's not the one driving the wheelchair, yeah. Let's see. I don't know the facility. They mentioned one particularly, and then they kept saying facility. And they had a difficult time apparently ridding him from this facility to get him to court. That was an issue the judge addressed last week about making sure he was there every day for trial. And in fact, the judge said, well, we're going to have trial on Monday. I don't know where you're going to be, Mr. Brooks, which was a really weird thing to say. But I don't know where he's at. Less rape in the county. See, I feel like there would be more. The county is like the Wild West compared to the prison facilities, at least in Michigan. Grounds. Yep, so that's all we have. Brooks has pled no contest to 2 counts. I'm not sure why it was no contest. Generally, you do that when there's potential civil liabilities or there's like a mental issue that would prevent you from having the memory of the events that led you to get the criminal charges in the first place. So, for example, if you have a psychosis of some sort, and you literally don't have a memory of the events, the courts will allow you to plead no contest because you can see on paper that there's enough evidence to convict you, but you don't have any independent memory in order to establish those facts yourself. Or the other grounds would be potential civil liability. I don't know why either one of those would exist in this case, but it's a no contest. He's going to get probably 10 years, especially with the underlying domestic violence component. And we'll just stack that on top of his life sentences. Okay, well, that's about it. It's a little disappointing, but like I think Aaron said in the chat, it's probably best for the victims. Is that you, Aaron? Somebody said that in the chat. Best for the victim to not have to testify again and, look at Brooks in the face again. She can move on, her and her child, and all that good stuff. So with that, I will just close this out. Thank you. This has been a Salvador Dali MLS production. And y'all have a wonderful day. I would redirect if I could. Unfortunately, I can't yet. So I know Nick is streaming and Baker's streaming right now. And I'm not sure who else is streaming. But those 2 guys are, so go check them out. And we'll see you all on the next one.
When I was young, my dad